everyone. Welcome. Thank you for joining us today for our weekly webinar series. This webinar today is about how to handle investigations against you as an employee, which is useful for every employee to know, regardless of the size of the employer. Before we get into today's topic, a little bit about us. We were founded in 2016, and our primary focus areas are employment law, human rights law, workplace investigations, which is also a subset of employment law, labor law, as well as litigation. My name is Mariel Gergis, and I'm joined today by my friend and colleague, Charles Miller. We are both senior associate lawyers at Achkar Law, and let's get straight into it. So what is a workplace investigation? It is a formal process conducted by an employer to look into and address certain allegations. This can include complaints about misconduct, policy violations, or other workplace issues. So some examples of complaints are, for instance, harassment. If a colleague keeps messaging another colleague to hang out after work, that could be seen as sexual harassment. A colleague might then make that type of complaint that the employer looks into. Another example would be discrimination. If someone is treating someone else different or poorly because of gender, race, or any of those other human rights grounds, as we've discussed in our previous webinars, that might also lead to something that gets investigated as well. More common, what we see are policy violations. So for instance, time theft or breaches of confidentiality. As part of the investigation, the investigator will actually gather evidence, interview everyone who might be relevant, try to determine what actually happened, come to a conclusion, and they may actually give recommendations for next steps as well. The people involved. First and foremost, it is the investigator. So this could be management, someone from human resources, or a third-party company or lawyer that gets involved. The employee who made the complaint is also known as the complainant. They will be a key participant as part of this investigation. The employee who's being investigated, otherwise known as the accused. Any potential witnesses as well who saw the incident might end up being part of this investigation as well. So you are under investigation. What do you do first? Most important thing is to stay calm and also remember what the investigation is for. The investigator is just trying to gather facts to establish what actually happened. If you are sent home for part of the investigation, don't talk about it with your colleagues or try to keep working. Follow the policies in place and get updates from your employer regularly. Review the company's investigation procedures if they have any. Usually this will outline next steps. Most common what we see is investigators meeting with the complainant first to get an idea about what the actual complaint is about. After that, the investigator might speak to the accused or to a witness. So let's go straight into your rights and responsibilities. First and foremost, you actually have the right to be informed of the allegation or allegations made against you before the interview. After all, you can't respond to what you do not know about. So if the employer is trying to schedule an interview and you're not exactly sure what the allegations are about, you are allowed to ask for more details first. Though during the investigation, one of the first things the investigator will do is outline what you're actually being accused of, just to make sure you actually understand, for instance, if something happened on a certain date, that the investigation relates to incidences on that particular date. You also have the right to representation, and this can take a few different forms. If you're in a unionized environment, you have the right to have your union rep there with you. This could be someone to take notes or be there for moral support, just so that you're not alone. You can also book a consultation with an experienced lawyer like one at our firm to ask any questions that you have before attending the actual interview. You also have the option to ask that a lawyer be present during the interview itself. Though if you're trying to bring someone into the room, just let your employer know before that investigation meeting first. Understanding your responsibilities. It's to actually cooperate with the investigation and answer the questions being asked. So for most investigations, you will only be interviewed once. And this is key because this is your time to outline your side of the story. So when they give you that time to show up, if you're comfortable, show up and give your version of the story. Some people are comfortable giving their events in writing. We actually recommend that people write down, what actually happened and when, to have that timeline in place before going to answer those questions. Because again, for the most part, you get one shot to give your version of events. Provide honest and complete information. So part of this also includes, if you're not sure about an answer, let the interviewer know. Don't guess. For instance, if the interviewer tries to ask you whether Stacy and Linda were present for the incident, but you're not actually sure, simply say that you're not sure. guessing incorrectly can affect your credibility and raise doubts about your recollection of events. So even if this was the only item you're guessing, it does raise a little bit of a concern with how truthful everything else was. So it's in your best interest to just be honest about everything that's being said, especially if the interviewer is going to be asking more than one person questions. Just make sure your version of events holds up and answer questions honestly. If you're not sure or don't understand the question, just ask the interviewer to rephrase it.
Thank you so much for that, Marielle. So now we know a bit of our rights, what to expect when an investigation is launched, and on what terms an investigation is launched. Let's take it to the situation. You have been charged with a potential harassment complaint or some sort of workplace violation, and now you are about to be interviewed. So what should you expect? What should you do? The first thing to consider when you are the target of an investigation is to consider that your credibility as a witness and as the person giving testimony or giving evidence is central to what an investigator is really looking at. They're going to be asking you, and when we do investigations, I'll be asking you, what happened? When did it happen? Who did it happen with? And your credibility and how much I trust the information you're giving me plays a massive impact in the end of report. So if you know you're about to be interviewed, the first thing you're going to want to do is gather as much relevant information as possible. We're talking documents, emails, text messages, any sort of items to give credibility to what you're saying is the full story. It is also helpful to actually have a list of key events and dates. Most of our reports that we draft are in chronological order. They're not, spread across, going backwards and forwards, jumping forward and ahead of time like you might see in the movies. We are telling a straightforward story chronologically. So having that framework in mind when telling your story is very important. So it'd be a good idea to actually have a list prepared in advance, as well as a list of potential witnesses, because as the investigator, we're often, especially in an employment setting investigation, which is 90% of what we do, the employer themselves are the ones who are going to tell us exactly who we should be investigating, but the employer doesn't necessarily have the full story. In fact, you might know a couple other witnesses who would actually speak to the events. So if let's say we're telling this in the context of one of your colleagues, let's say you're the one being interviewed, and one of your colleagues has accused you of sending too many flirtatious text messages after work, just like the example Marielle gave about inviting them after work. Well, you might not be you'll have your version of events. You're going to want to have those text messages, you'll have those documents, but there might be other people involved in the circumstances that can actually give a bit more information to what went on there, provide a bit more context. One of the other things we recommend you do is actually practice your responses in terms of thinking about questions and practicing your answers. Now, when we suggest that, you might be inclined to think we're suggesting make up an answer. That's not what we're suggesting. It's perfectly reasonable to prepare and practice and rehearse your responses, because being investigated for any sort of complaint such as harassment, discrimination, or a policy violation is extremely stressful. You're going to feel like you're in the hot seat and under a lot of pressure. There's a lot of information you want to gather. So it's perfectly reasonable to prepare yourself for that. In fact, we recommend that because, like I said before, credibility plays a big role here. And if I'm asking you questions and you're sweating and you're jittery and you're stuttering, you're just jumping back and forth, which would be reasonable given the circumstances, it may come across that you're being evasive or elusive or hiding information, or that you're feeling guilty. And that will come across in how you give answers. That might hurt your credibility. So if you know an investigation is coming, prepare your evidence, consider the questions, and rehearse and prepare to give it. In terms of giving your answers, and while I'm asking you questions, the actual interview will feel a lot like a cross-examination. But it's not. It's a fact-finding endeavor. I'm there to ask you about what happened and honestly get your version of events. This isn't like an interrogation you might see in those good cop, bad cop police shows. We honestly, whether or not you're guilty of something or substantiated or not substantiated claims are made against you, is not what the investigator is trying to get at. They're trying to get at the truth. And they're not trying to necessarily find a villain like you might see in these cop shows. That's not the purpose. So when you're giving your answers, keep that framework in mind and stay calm and respectful. Investigators like myself will be asking you questions that are going to stress you out. They're going to make you feel defensive. Guard yourself, protect your emotions on that, because if you come across defensive, it's going to send the message that you have a reason to be defensive. It's going to send the message that perhaps your credibility should be taken into question. When you're being asked the questions, listen carefully and only answer the questions directly. Often I've seen it where I'll ask a question and the person will start giving an answer that is not really related to the question I asked, and I have to repeat the question. It can be draining, it can drag on the examination, and it can also potentially send the message that you're trying to hide something or trying to get around or be evasive and answer the question. But the best witnesses, the best here are the ones who are calm and who just answer the question directly. They're clear, they're concise, they're factual. People who are like that, who are cool, come across as though they're honest and that their credibility is above reproach. Even if you are potentially guilty of a harassment or workplace policy violation, if you come across as highly credible and you're acknowledging that there might be some faults there, that's great, because now you get to present your version of events. You come across as extremely credible. You're not denying the fact, especially in their example of sending flirtatious texts. Those text messages will exist. You can't deny that they exist, but you can provide context. And if you're already demonstrated to be credible, then your context will really sway how we view these text messages or the circumstances surrounding it. We also recommend avoid speculation and sticking to the facts. By speculation, we mean don't necessarily dive into what you think other people thought or about other things that you have no knowledge about. Throwing up alternative theories is just going to clutter the issue. Really, you're just there to give your version of events, verify any facts, and answer any questions we might have. You've completed with the investigation. You've given all the facts. You've been straightforward. You've been honest. Your credibility is above reproach. Now what? Well, you're going to wait a little while, likely a month or two, before the examiner has examined all the witnesses and provided and collated a formal report that they will then give to the person who hired them, which in this case, the employer. This is usually employment settings. The employer will then take that report and use it to inform their decision. Now, unfortunately, 9 times out of 10, as the employee who's been the target of the investigation, you actually don't get a copy of that report. In fact, it's very unlikely that you will be given a copy of it. What you will be given is a summary from your employer that talks about how the report came about, what the report said, and whether the allegations made against you were substantiated, meaning that they were true, or not substantiated, meaning that it was determined that there's absolutely no merit to them. Now, if the claim is found to be substantiated, so again, let's say we're using our 30 text message example, you sent the text messages, it was determined that you were intending to be flirtatious, it's substantiated, what do you do next? Usually the employer will start to impose some sort of remedial discipline, usually a progressive discipline approach, but just because that happened doesn't necessarily mean you have to agree with the findings. In fact, if your workplace has a investigation policy, there might be an appeals process where you can challenge the results, especially in a unionized setting. You can actually challenge a lot of these results. And sometimes in the employment setting, you can challenge the results. Look at your policy to see if there's an avenue for that. And in which case, then you've now got the results, so work towards the remedial discipline. However, what if the results are not substantiated? Well, this is very awkward for many people because you've been accused of harassment, or workplace some sort of policy violation, but the report has determined that they're unsubstantiated. There's no ground or merit to these complaints. Great, you've been exonerated. You're not going to face any sort of remedial punishment, but now you have to go back into the same workplace with the employer who filed an investigation against you and with a colleague or colleagues who accused you of something. That can be deeply uncomfortable. And you'd be very reasonable to feel as though that you're going to have a hard time maintaining a positive working relationship with them. But this is actually a very important part after the investigation process, is to not only maintain professionalism, but rebuild trust. And if you're the accused who was exonerated, the duty is on you to provide an opening for people to work towards rebuilding that trust with you. Be graceful in allowing the employer to rebuild their relationship. Maybe even be graceful in allowing the person who made the accusation to come forward with rebuilding that friendship or that relationship together as well. And alternatively, if the claims are substantiated, you can also work towards rebuilding a better, more positive working relationship as well. So after the investigation is important as well. A few last tips to consider before we go into the question in the question period, and we can gather some questions from the rest of the audience here. When you are the target of a workplace investigation, the first thing we recommend you do is seek support. This is not something you need to do alone. Being the target of investigation can feel shameful, but it's just part of like a claims raised is just part of a formal process. We do recommend speaking to a lawyer to get some advice. Our firm does offer consultations to help prepare people for investigations and for being examined and being investigated in terms of how to best answer a question, how to conduct themselves, what evidence they might want to gather to have prepared. This is all the best way to prepare yourself, because the worst situation you could run into is if you're accused of some sort of harassment, you're actually completely innocent, but the evidence is murky and you don't come across in a way that is believable or credible, in which case the claims could be found to be substantiated when nothing could be further from the truth. So it's best to set yourself up for success by getting that advice. Another thing to do is actually to seek that emotional support from friends and family. Workplace investigations are extraordinarily stressful. And so it would be ideal to actually get that emotional support if the claims couldn't be further from the truth, or if the claims there is some merit to the accusations, then that's a very important time to actually get that support in terms of deciding next steps. And the last thing to keep in mind is to maintain confidentiality. Investigations often come with a non-disclosure agreement, which means if you are the topic of an investigation, you can't go and talk to your colleagues about it, which can be deeply frustrating, because if you're the topic of an investigation, you're going to feel like people already know about it, and you're going to want to talk about it. You're going to want to seek support from friends. You're going to go and talk to potential witnesses, but you mustn't do that. You need to absolutely make it seem as though you're not trying to influence results or influence the investigation. You also don't want to damage the air of confidentiality, because employers also want to keep this confidential. And if you do reveal publicly the nature of the investigation, that could be grounds for some sort of discipline against you. Now, you can still go to friends and family outside of the sphere to seek that support, but keeping it as private as possible, especially within the workplace, is extremely important in these situations. So I think we have time for some questions and answers. Marielle?
Yes, we have some questions. Charlie, the first question here. If human resources tries to schedule an interview with me, but I'm too stressed to go, what should I do?
Great question. It's quite reasonable for you to take a bit of time to gather your thoughts and maybe go and seek some counseling or some other emotional support until you're emotionally ready to give your report or to go under examination. Employers and HR should be reasonable. They are going to want to interview you as soon as possible, but it's perfectly reasonable to ask for a bit of time to calm down, collect your thoughts, prepare your evidence, or get emotionally ready for it. And in fact, if employers push you too hard to take part in the investigation before you're emotionally ready, that could exhibit some level of bad faith this side of the employer. So the advice we give to employers when trying to schedule this is try to do it as soon as possible, but be reasonable if the employee or the witness needs a bit of time to gather their thoughts. So yes, feel comfortable asking for a bit of time.
Thank you for that. And if I have text messages that disproves a complaint made against me, should I send it to the investigator?
Yes. Generally speaking, when you're gathering the documents and evidence, the investigator is going to want to see them. Now, be careful with the evidence you do show, because if you want some evidence to be private, you may need to make that clear to the investigator that you don't want this shared. You just want them to be aware of the facts. Investigators may let you know they are required to share it, because sometimes, for instance, if you're the one who's being accused of sending 30 texts, investigators will want to then show those text messages to the person being examined, or to yourself if you're the one being accused of it, so you can see what they're looking at. In contrast, if you're the one being investigated and you have text messages or emails or some sort of evidence to disprove it or to provide more context to it, you can send it to the investigator, but be mindful that there's very high probability they're going to ask your consent to then share that with those messages with management who hired them or with the other person, one of the other witnesses. So by all means, share it, because that could be your golden ticket or your smoking gun that you're completely innocent. But be mindful that if you want to keep anything private, chances are within the investigation sphere, at least a few people are going to find out or see them.
What should I do if I made a complaint and the employer didn't actually do enough to investigate it?
The word enough there is very, very crucial. So, for instance, if you make a workplace harassment complaint, you probably heard in some of our other webinars that the employer has an active duty to make sure that they have a harassment-free workplace environment, such that if they become aware that harassment is ongoing or bullying has occurred or there's some sort of policy violation, they have an active duty under legislation to investigate it or to quash it and keep it from happening again. If you make a complaint to HR and they do nothing with it, well, then the employer has violated their duty, and the complaining employee may actually have grounds to bring a claim against their employer. In terms of the circumstance, what we call a constructive dismissal claim, where the employer has created or allowed a toxic workplace, failed in their duty to provide a safe space, and therefore force you to resign. Those damages could be not only reasonable notice, but general damages for aggravated, punitive, all sorts of substantial damages. But the key word you used there was, have they done enough? So I'm going to give you the answer that lawyers love to use, and that is, it depends. What's enough? What did the situation call for? What were the circumstances of the complaint? And if you, the complainant, think it's enough versus the employer thinks it's enough, that could come down to a trier of fact. And so if they ask the person, hey, did you harass this colleague of yours? And the person says no. And then the employer comes back to you and says, yeah, they said no, we believe them, go kick rocks. Chances are that's not enough. That's the employer's going to be in a lot of trouble. If the employer interviewed both sides, weighed the credibility of each witness, and said that your claim was unsubstantiated and there was a lack of evidence, then the employer might have done enough to actually investigate it. But whether or not an employer's done enough is actually a great question to speak to legal counsel about. Because if they haven't done enough, then there's a claim there, not just for the harassment, but for the failure to provide a harassment-free workplace. So it depends. Ask a lawyer.
I get accused of breaching a harassment policy, but I'm innocent. The investigation said I did it, and now the employer wants me to sign confirming, I suppose, a document here that I harassed someone. What should I do?
When employers ask you to sign a document after an investigation, it's the employer themselves that are crossing their T's and dotting their I's. They've got the investigation report that says that you're guilty. They have relied on that as evidence that you are, and now they want you to sign and confirm that you did it. If you sign that document alleging that you were guilty of this harassment or this violation, then that's you acknowledging in writing that you agree with the findings and you agree with the remedial results. If you were adamant that this was a faulty investigation, adamant of your innocence, then we wouldn't recommend signing that document. There'd be no benefit to you necessarily to signing it, unless by signing the document, the employer agrees that it will be buried and done for, and you can move on with your life. You may consider signing it on those terms, but 9 times out of 10, it's not going to benefit you in any way to sign it. The only thing to consider is that the employer may decide that if you refuse to sign it, then they might have grounds for discipline, possibly termination. In those circumstances, we highly recommend speaking to a lawyer, because if we can determine that the investigation was completely flawed and that the employer getting you to sign this is bad faith, then you might have a claim for constructive dismissal as well. So again, favorite lawyer answer, it depends. But more often than not, if you're adamant that you're innocent of these allegations, regardless of the investigation, then we wouldn't necessarily recommend signing any document before speaking to a lawyer.
What if I am being investigated for conduct I did?
For conduct you did, I'm going to assume it's in terms of there is some harassment that you might be guilty of or some bullying you might be guilty of. If you are being investigated for it, the best thing to do is, as we kind of mentioned in this webinar, is to actually gather the evidence and sit tight. Don't go and talk to people. Don't go and influence the witnesses. Gather your evidence and be prepared to tell your version of events. Because if it's conduct you did, we're going to assume that there's reason for it. Most often, people are not committing harassment or bullying or workplace violations intentionally because they just love chaos. There might be some reason for why you did it. So providing that context is going to be important. If you're the subject of that type of investigation, gather the evidence, practice your answers, just as we discussed.
What if I made a complaint, the investigation was in my favor, but now the accused is upset, contacting me, and I'm worried about what they might do next?
So we have seen that happen more than a handful of times. Often it happens in cases where you got what's known as a vexatious complainer or vexatious litigant in the legal context. These are people who are adamant that they are the victim of some sort of harassment. And even if the investigation finds it to be not substantiated, this person really has a chip on their shoulder or something in their craw about it. If you were the topic of investigation, you're innocent, and it was found to be not substantiated, but now the complainant won't stop harassing you, well, guess what? Now you have grounds to raise a complaint to the employer to say, hey, listen, so-and-so now won't stop messaging me, and they're now harassing me. And I think that there's something wrong there. So now the employer has to do another investigation, now into the complainant for harassing you. Because when an investigation is done, it's found to be not substantiated, unless there's a good appeals process, that's kind of the end of the story. So if the complainant's now harassing you, you have options. Go to HR, go to your employer, or potentially speak to a lawyer if not enough's being done to keep you safe. Because by safe, I mean you deserve a harassment-free workplace.
If the complainant is spreading rumors about the investigation to our friends and colleagues, who should I tell?
Great question. Go straight to the investigator and your employer, because often, as I mentioned before, a lot of investigations have a non-disclosure agreement, so you can't be telling people about the nature of the investigation. And also, rumor mongering or spreading rumors about somebody, if you've seen some of our other webinars, is a form of workplace bullying. If they're spreading rumors about the investigation and marring your image or marring your reputation, that's another concurrent investigation gets launched. You see now how these things can get quite messy. If you've got some energetic people in your workplace, you can find situations where multiple investigations are launched, involving the same set of facts, same nexus of facts. So if someone starts spreading rumor about you or break the non-disclosure agreement, that person will likely be found culpable of some sort of remedial discipline. Go straight to HR, mention it to the investigator, mention it to your employer, because they will want to quash it immediately to keep things clean.
The individual has alleged harassment by the employer since 2018, and to date, the employer has only acknowledged the 2021 investigation report in 2024, so 3 years after, and has not actioned the report. What options are available to this employee?
In any sort of complaint that comes forward, there's usually a 2-year limitations period for bringing any sort of action forward or any sort of claim against the employer. So harassment complaints going back to 2018 would likely not be able to be a good subject for potential claim if we're leaning towards now suing the employer for failing to investigate. But it can be part of the overall narrative and story you tell where historically this employer has not investigated or not gone into things. If the employer has a 2021 report, that's the only thing that they're acknowledging, but they haven't actioned any sort of progressive discipline, I'm guessing is the next step we're asking here. Doing the report is great, but the report is just a tool used by the employer to decide what to do next. And if the claims are substantiated that some harassment took place, the employer now has an active duty, especially, to now take progressive discipline against the person who the claims were substantiated against. And if the employer doesn't, then they failed in their duty to provide a harassment-free workplace, and the complainant will have grounds to bring a claim for constructive dismissal or any sort of other claim against the employer. Absolutely in those circumstances, please do give us a call, because there might be something there that should be looked into.
Thank you, Charlie.
So everyone, thank you so much for joining today. And Mariel, thank you so much as well. Please feel free to reach out to us. That's our contact information there. We hope everyone has a wonderful afternoon. Thank you again for joining us, and we will see you next week.